Hi, I'm John Milikowsky, founder of Milikowsky Tax Law. Today we're going to be talking about a new bill, Assembly Bill 5, that the governor is expected to sign into law in October. And this bill relates to independent contractors. So California is very much opposed to having a traditional independent contractor unless you can meet now what is going to be 3 elements. This is based upon the Dynamex case, which was passed in early 2018. Previously, there were 13 factors that determined whether a worker was an independent contractor or an employee. And basically, EDD would weigh them and say, well, are there more factors as an employee or more factors as an independent contractor? And if it came out that there were more factors supporting independent contractor classification, they would rule that the workers of a company were independent contractors. Now we have a Dynamex case. And Dynamex, again, was passed in early 2018, or at least there was a court case by the California Supreme Court, and it held that that a company has the burden of proof and it has to meet all 3 elements. If all 3 elements were not met, then workers were automatically classified as employees. So what are those 3 elements? The first one is that the company who's hiring an independent contractor cannot have control over that contractor. Control comes in many ways. For instance, if you work for a company and as a contractor, maybe I'm a mortgage broker, and I'm independent and I deal with various banks and maybe one specific company I'm also selling for them. And I carry around that company's business card, and my website is really, my information's on that company's website. It seems that they have a lot of control over how I do business. You know, if they're also telling me what I have to say to the customers, and if I have a script and things like that, if I have restrictions and if I have reporting requirements to that company, that's the type of control that the court will be looking at. Other types of control really relate to money. In one case that I had, we represented a law firm. The law firm had several independent contractor attorneys, and the court held in that case that the attorneys were not independent contractors because control was achieved through money. The client paid funds to the law firm, and the law firm then paid the contractor attorney, and so the law firm really had control over how the attorney would perform their work. So that's another form of control. The second element of Dynamex relates to whether the work performed by the worker is very similar to the work performed by the company that's hiring that worker. So if I have a plumbing company and I have a bunch of employees who are plumbers, and I get a lot of work and I can't fill all the projects, so I need to now hire a temporary worker as an independent contractor, maybe I'll hire a plumber, another plumber. That plumber does the exact same type of work as my company, therefore would not meet the second element of Dynamex. Maybe a little variation of the facts might change the whole situation or the outcome. So if I get a commercial plumbing job, but I almost entirely do residential plumbing work, if I hire that 1099 contractor who does commercial work, that potentially could be different than what my company does, different types of work. Commercial jobs have a very different type of specification and experience level that's required. The third element of Dynamex relates to whether the contractor has an established business that's separate from the company that's hiring that worker, established business or trade, and whether the worker's work that they're performing relates to that independent business. So for instance, say I have, I'm a 1099 contractor and I do plumbing work. And then somebody calls me and says, hey, John, I need you to do carpentry work. Well, I don't have any clients, a Rolodex of clients currently as doing carpentry work. I don't advertise to do carpentry work. I don't have a website. I don't have a business card. I don't even have insurance that covers that carpentry work. All of my established business and trade relates to plumbing. So in that case, if I'm going to be doing carpentry work, potentially that work I would not be qualified as an independent contractor and I would be reclassified as an employee. So we're really looking at this from the perspective of the company who hires independent contractors and whether their workforce, if they have a lot of independent contractors, might be reclassified. Because if they are reclassified, what will happen is EDD will go back 3 years for the audit period, that's generally what it is, and assess payroll taxes for all of the payments that should have been classified as wages but were not. You might also have a problem with workers' compensation. If you don't have any workers' compensation, it would cover independent contractors. They generally don't, generally only covers employees. So there's a lot of ramifications that come from this decision, the Dynamex decision. And the governor is anticipated to sign this new bill, AB 5, in October, and the law, if it passes, will then become law January 1st, 2020. Thank you very much for listening to my blog.